Hi, good afternoon. I do not want to interrupt your eating, so please do continue, but happily we are going to receive some wise words while we eat. And so I'm very pleased to introduce Professor David Scheffer, who is also the former United States Ambassador at Large for War Crimes. I think the biography actually in your program seems to omit that, which is of course quite critical and significant to Professor Scheffer's body of work and his significance here today. As ambassador, Professor Scheffer participated in the creation of the International Criminal Tribunals for the former Yugoslavia and Rwanda, the Special Court for Sierra Leone, and the Khmer Rouge Tribunal. He also played a critical part, as Professor Stereo mentioned earlier, in negotiating and signing the Rome Statute that, of course, created the International Criminal Court. Professor Scheffer is now the director of the Center for International Human Rights and teaches a number of those subjects at Northwestern, but we are particularly pleased to have him here today. So please join me in welcoming him.
Well, it's a tremendous pleasure for me to be back here. You know, I've come back many times over the years because your dean, Michael Scharf, if he calls and invites, I respond. I've known Michael since 1993, and we first met in the State Department. I had just come in with Madeleine Albright. He was about to well, he was there for a number of months and then moved off to academia from Legal Advisor's Office. And on one of his final days, he marched into my office. I was counsel to Ambassador Albright, and he just dumped a 3-ring binder on my desk. And he said, "Dave, the International Criminal Court, good luck." And of course, I ran with that agenda for 8 years thereafter for the United States government. So what I'd like to do is, of course, first thank Dean Michael Scharf. I am entirely humbled to be in the presence of Judge Bergenthal, who I intersected with many times during the years. And I'm going to shame you for a moment, Tom, because when I was Ambassador at Large for War Crimes Issues in the late 1990s, he was on the Human Rights Committee. And you remember in his talk this morning, he said that I think he took pride in being an independent mind on the committee. And so I, of course, put him in an awkward position a couple of times. I'd be up in New York at the UN, and I'd know that he was sitting in the Human Rights Committee there, and I would walk in. Everyone kind of knew who I was and the country I represented. I'd sit down for a nice chat with Tom, essentially destroying his independence before all of these people. But we had important things to talk about, and Tom was always tremendously helpful and independently minded in advising myself as a representative of the U.S. government where truth resides with human rights. Now, I want to, of course, thank Professor Cover for that nice introduction. What I'm going to say overlaps a bit, frankly, a fair amount, with what the first panel talked about. Individuals who are, I hold in the highest esteem, and of course, they covered some of the subjects that I will cover. As you get older, you find that your place in life is to amplify, not create. And so I'm going to amplify some of the things that were said on the first panel, but I'm also going to add a fair amount to what my colleagues on the first panel talked about. The dialogue at this conference focuses on 3 broad areas relating to corporate liability for human rights violations: accountability, transparency, and morality. I will bore into accountability while recognizing up front that impunity for corporate behavior in the realm of human rights is being challenged with legislative and stakeholder initiatives in reporting, namely transparency and development of guidelines, and by expressions of morality at the CEO level. I point to just one example of guidelines, namely the Corporate Crimes Principles, issued in October 2016 by the International Corporate Accountability Roundtable in Washington and by Amnesty International. It's an extremely useful set of 10 principles to guide those who aim to hold corporations accountable. My colleagues James Stewart and Alex Whiting served as experts in the preparation of the principles, and I commend them to you to review. But the force of morality can be stronger than anything we legislate, anything we uphold in the courts of law globally, and anything we mandate for reports and other instruments of transparency, including an aggressive mainstream media and Fifth Estate. None of us are naive enough to think that corporate impunity is somehow gasping its last breath. Far from it. But the tide is turning. The pathway to corporate responsibility, which is being built in bold defiance of impunity, is not a straight line, and it does not and should not traverse only courtrooms. The issue of overcoming corporate impunity for human rights violations and how we frame our analysis of it is and must be multidimensional. My colleague, Professor Caroline Cave, is pioneering innovative ways to achieve corporate responsibility with non-litigious methodologies, which you heard about in the last panel, and I applaud that effort and have seen it unfold for many years now. But I speak here today of two developments in the field of accountability. I begin with the notable case of Jesner v. Arab Bank, which you heard about in the first panel, which will be argued before the Supreme Court on October 11. Full disclosure, I filed an amicus brief on behalf of the petitioners in the case. While the case concerns civil rather than criminal liability, the fate of corporate liability under the Alien Tort Statute and how such liability is framed by egregious human rights violations hangs in the balance, unless the Supreme Court simply invokes the presumption against extraterritoriality in favor of Arab Bank. Now, I know that Dean Stereo this morning talked about the brief from the Department of Justice, and there was skepticism expressed by DOJ that the case would possibly even touch on corporate liability and rather just be knocked out once again, just like in Kiobel, with the presumption against extraterritoriality. I doubt that particular outcome because the case presumably was granted on cert only for the purpose of addressing the issue of corporate liability. Repeating the Kiobel exercise of raising the issue of corporate liability only to bury it under the presumption against extraterritoriality would be an odd undertaking and outcome for the Supreme Court. There is a clear circuit split on the issue of corporate liability, reaffirmed by the Second Circuit in Jesner. So the battle lines are drawn and the time has arrived. The Alien Tort Statute either covers, as violators of the law of nations or U.S. treaties, corporations as well as natural persons, or it only covers natural persons. The relatively recent split in the circuits must be repaired. In my amicus brief, I examined two issues that the Supreme Court justices should take note of during their deliberations. First, the Second Circuit and the respondent continue to rely on the Rome Statute and the negotiations leading to it, to its conclusion, to deny liability for corporations. Take it from someone who was there every day. There is simply no basis in the history of the negotiations leading to the Rome Statute of the ICC that prohibits civil liability of corporations for commission of or complicity in the commission of genocide, crimes against humanity, or war crimes, which are the most egregious types of human rights violations. Our relatively brief discussions about the status of criminal liability of corporations for the commission of or complicity in atrocity crimes led to a dead end, but that only speaks to the issue of criminal liability. We were not discussing civil liability, which is the only form of liability under the Alien Tort Statute, but has no application whatsoever, even for natural persons, under the Rome Statute. Let me bore into this a bit, because this issue remains central, at least to the issue of civil liabilities for corporations under the Alien Tort Statute. And if that is eviscerated by the Supreme Court, thus immunizing corporations, then I suggest that criminal liability will be much harder to establish in the years ahead. We may need to strengthen the foundation for civil liability before building new frameworks for criminal liability. The Second Circuit and the respondent assume incorrectly that the 1998 Rome Treaty, which exclusively and deliberately focused on the establishment of a criminal court, purposely reflected a widely accepted international consensus against all criminal and civil liability of corporations for crimes against the law of nations, as if corporations essentially are immunized from any legal liability in their operations. That incorrect assumption is flatly refuted by the history of the Rome negotiations and the structure of the Rome Treaty itself, both of which expressly and solely address criminal liability. Second Circuit also wrongly assumes that this purported international consensus, namely against holding corporations accountable in civil as well as criminal legal proceedings, continues to be accepted widely in customary international law. Even disregarding the fundamental error of its predicate assumption, the notion that there is a continuing consensus against civil liability is contradicted by the broad acceptance among legal systems that public law can provide remedies for corporate misconduct. Indeed, in addition to the widespread acceptance of civil liability, there is an increasing acceptance of criminal liability in the almost 2 decades since the Rome Treaty was completed. The Second Circuit and the respondent hold a position that in its final analysis would entitle corporations to commit or be accomplices in atrocity crimes wherever they operate in the world, unless there is a national law on the territory where they operate that outlaws specific crimes by juridical persons. Luckily, provided the Supreme Court so rules, in the United States there is the Alien Tort Statute that at least imposes civil liability on such corporate conduct against aliens, including when it occurs on foreign territory and, under the Kiobel test, touches and concerns the United States. So it is true, but irrelevant to the issue before the Supreme Court, that there was divergence among states and legal systems at the time of the Rome Treaty's negotiation regarding the applicability of criminal statutes to juridical persons that cannot be subjected to the traditional criminal penalty of deprivation of liberty. Exclusion of corporations from ICC prosecution was inevitable, not because states agreed that corporations are above the law as a matter of right or of principle, but because a fundamental underpinning of the Rome Treaty is the preference for and deference to domestic prosecution, the principle of complementarity, and the obligation of states parties to undertake the capacity to prosecute. If a legal system did not hold juridical persons liable under criminal law, then under the Rome Treaty, that national system likely would fail the test of complementarity. By the way, the U.S. delegation at Rome, which I headed, was fully aware of the fact that corporations are subject to criminal sanctions in the United States. That, including juridical persons in the Rome Statute, would have been an easy give for the United States if we only had our own jurisdiction to consider. And I thought Professor Beale's remarks this morning were right on point. And you know, when I say easy give, yes, easy give, but I can also imagine many months of consultation with the Department of Justice, the Department of Commerce, the White House, many state governments as to whether or not we had authority in Rome to stretch the Rome statute to cover corporations in the United States and add another criminal layer of conduct over corporations. That would have required endless interagency meetings of discussions, which never happened. But given the diversity of the treatment of corporate criminal liability globally, it was not possible to negotiate a new standard of corporate criminal liability with universal application in the time frame permitted for concluding the Rome Treaty. Equally, it was not plausible to foresee implementation of the complementarity principle of the Rome Treaty in light of such differences in criminal liability for juridical persons among so many national jurisdictions. Nor was it possible in so few days at Rome to consider the complex revisions to the long evolving text of the treaty that would be required to extend the personal jurisdiction to corporations. The omission in the Rome Treaty of provisions for civil proceedings against juridical persons is utterly insignificant. To the contrary, the negotiations in Rome leading to the creation of the ICC understandably steered clear of civil liability for tort actions by multinational corporations as well as by natural persons, because civil liability fell outside of the self-described criminal tribunal. No conclusion can be drawn, either from the negotiations leading to the treaty or from the absence of corporate criminal or civil liability in the treaty, that undermines a general principle of law regarding corporate civil liability, or that prevents national courts from holding corporations liable in civil damages for torts committed on national or foreign territory. Nor have legal systems frozen in time. The Rome Treaty expressly accepted that legal systems and international law would evolve. Since 1998, corporate criminal liability has been growing rapidly across the globe. A significant number of nations that have ratified the Rome Treaty, indeed 29 countries that I list in my amicus brief, also enacted national implementing legislation that establishes corporate criminal liability for atrocity crimes falling within the jurisdiction of the Rome Treaty, or have adopted comparable laws for the same or other serious crimes. These states certainly did not act as if the Rome Treaty precluded expanding corporate liability into the realm of atrocity crimes. Indeed, one might speculate that the Rome Treaty, by focusing ratifying states' attention on atrocity crimes, provided an impetus to accord greater accountability within their domestic legal systems, and it happened. These developments point to the evolving codification of corporate criminal liability at the national level that aligns with the long-standing general principle of law of corporate civil liability for torts that is found in almost all jurisdictions, including the United States, and with respect to Jesner v. Arab Bank, a statute, the Alien Tort Statute. At the international level, the Special Tribunal for Lebanon, and Professor Stawn spoke to this this morning, and Professor Cave actually has published a law review article in the George Washington University Law Review, International Law Review, deeply going into the whole case before the Special Tribunal for Lebanon, which is an international criminal tribunal, and it found in 2014 in a contempt case that corporate criminal liability has become a general principle of law. It's a contempt case, but still, it's out there. The respondent scoffs at this ruling in its brief as if the deliberations of a far-off tribunal are somehow meaningless. I think we all know better by now. The United Nations International Law Commission is crafting a convention on crimes against humanity that includes corporate criminal liability. The commentary to the inclusion of corporate liability in the draft convention states that the International Law Commission, quote, decided to include a provision on liability of legal persons for crimes against humanity, given the potential involvement of legal persons in acts committed as part of a widespread or systematic attack directed against a civilian population. In doing so, it has focused on language that has been widely accepted by states in the context of other crimes, and that contains considerable flexibility for states in the implementation of their obligation, close quote. The commentary also provides a rich source of authorities demonstrating the presence of corporate criminal liability in multilateral treaties. Professor Stawn mentioned the blockbuster number of 17 in his address this morning. Thus, while the Rome Treaty has been a major impetus in the trend towards corporate criminal liability in national legal systems, so too have the many recent multilateral treaties confirming corporate criminal liability for terrorism, bribery of foreign public officials in international business transactions, protection of the environment, transnational organized crime, corruption, the unauthorized transboundary movement of hazardous waste, and perhaps someday crimes against humanity. By the way, for the last 2 years, I've been chairman of an ABA working group on crimes against humanity, the aim of which is to finally codify within Title 18 crimes against humanity here in the United States. Right now, you cannot prosecute crimes against humanity as crimes against humanity. That, therefore, an ethnic cleanser from Africa can, settle down nicely in a nice home near Disney World and live happily ever after and never be subject to prosecution for the crimes against humanity which that individual committed outside of the United States, or even possibly within the United States, if you want to get technical about what is a crime against humanity. So we're trying to get that rectified, and one of the things that I think we need to be looking at more seriously than we have in the past is whether juridical persons should also be included within that statute, not just natural persons, but juridical persons. Of course, once you add them in, it might be much more difficult to get it adopted, but it's still a point to be discussed. But let's return to the fundamental premise of the Alien Tort Statute. It is a law that concerns civil liability. And while grave criminal conduct can certainly constitute violations of the law of nations, that fact does not translate into having to establish that corporations are subject to criminal liability as a matter of international law in order to be held responsible for criminal acts falling within the extreme degree of torts, no doubt, under a national statute of civil liability. It simply means that the criminality of certain actions, such as atrocity crimes, in which corporations engage, either directly or as accomplices, can certainly be subject to civil liability under a national statute, such as the Alien Tort Statute. Imposing additional criminal liability on corporations, which has been standard fare in the United States for corporate conduct for far more than a century, as we learned again from Sarah this morning, can be pursued under other laws and with further legislation. But to suggest that the Alien Tort Statute imposing only civil liability can only reach corporations if they are subject to criminal liability as a matter of international law is, frankly, nonsensical. And Judge Laval, in dissent in the Kiobel case in the Second Circuit, essentially said so. It defies logic. I leave to others the issue of whether the Alien Tort Statute was originally designed to reach juridical persons. For my purposes, it's important to stress that corporate impunity should not be read into the Alien Tort Statute. The other issue I want to address is corporate liability under the Rome Statute itself. As it now stands, only corporate officers or employees responsible for their company's criminal conduct that falls within the ICC's subject matter, territorial, and temporal and personal jurisdictions are subject to ICC investigation. I include employees because one must bear in mind that under the prosecutor's policy paper on case selection and prioritization, which was released on 15 September 2016, the prosecutor leaves open the option of bringing charges not only against, quote, against those persons who appear to be the most responsible for the identified crimes, close quote. She also, quote, she will, quote, first focus on the crimes base in order to identify the organizations, including their structures, and individuals allegedly responsible for the commission of the crimes, close quote. The reference to organizations can include a corporate entity. Nothing prohibits the prosecutor from looking at the corporation and how it has engaged in atrocity crimes before focusing on natural persons within the corporation. Do not be surprised to see corporate officials called as witnesses, avoiding culpability, but shedding light on how the corporation committed atrocity crimes or was complicit in their commission, and thus how the charged individual fits within the corporate juggernaut and steered it towards criminal conduct. The prosecution of a corporate president, CEO, CFO, or chairman of the board of directors will be a de facto prosecution of the corporation. At least that is a very real possibility before the ICC. And of course, we saw examples of that at the Nuremberg trials. I should note that there has been one corporate executive, Joshua Arap Sang, the former head of operations and well-known radio personality of Cass FM in Nairobi, Kenya, who faced prosecution at the ICC as an indirect co-perpetrator of 3 counts of crimes against humanity. He was charged with using coded messages in his radio broadcasts to commit murder, forcible transfer, and persecution. This all related to the post-election violence of 2007-2008. But the trial chamber vacated the charges against him on April 5, 2016. The shadow power of witness interference and political meddling likely intimidated critical witnesses. But the charges against Joshua Arap Sang broke the mold at the ICC and essentially put Cass FM, through the person of one of its corporate executives, on the road to a criminal trial. The prosecutor, in her policy paper, goes on to state that her investigation and prosecution of those most responsible, quote, may entail the need to consider the investigation and prosecution of a limited number of mid and high-level perpetrators in order to ultimately build the evidentiary foundations for cases against those most responsible, close quote. These types of individuals abound in the corporate world. Just ask the investigators immersed in the investigation of VW and other diesel engine automobile companies today. Is it a crime against humanity by corporate officials to knowingly, willingly, fraudulently, illegally cause the emission into the atmosphere of toxic chemicals that attack civilian populations en masse? I leave that as a question. Finally, the prosecutor, quote, may also decide to prosecute lower-level perpetrators where their conduct has been particularly grave or notorious, close quote. This could include employees at low levels, but who are perpetrators of atrocity crimes at such a high level of gravity or notoriety that they cannot, indeed must not, escape justice. In corporate operations, such individuals are well positioned to implement higher-level instructions or policies. It is generally corporations, either privately owned or state-owned, that accomplish the types of actions that the prosecutor identified in the policy paper as fair game for her office's investigation. And you heard this list this morning. I think Professor Stahn might have mentioned it, but, or Dean Stereo, but, quote, Rome Statute crimes that are committed by means of or that result in, inter alia, the destruction of the environment, the illegal exploitation of natural resources, or the illegal dispossession of land, close quote. So yes, corporations that are targeted for investigation and the framing of charges will have to be against corporate officers or employees and not the juridical person that employs them. But consider how powerful this tool can become in the future. Now, just allow me a moment of bluntness and hyperbole, okay? Let's just do it that way for just a moment, okay? On territorial jurisdiction alone, multinational corporations are cooked. They operate in and across many jurisdictions, and one or more of those jurisdictions is likely to be a state party to the Rome Statute, or a jurisdiction mandated by the UN Security Council to be investigated by the ICC, and where criminal conduct has occurred. On nationality jurisdiction, multinational corporations are cooked. They employ nationals of many countries, and it is entirely possible that one of those nationals will be in a position of authority and action within the corporation in connection with the company's engagement in atrocity crimes, even if the crimes are committed on the territory of a non-party state. On temporal jurisdiction, multinational corporations are cooked. There has been enough destruction of the environment, illegal exploitation of natural resources, and illegal dispossession of land since July 1, 2002, start date of the ICC, and even since any state party joined the ICC with respect to its own territory and what occurs there, to fully occupy investigative inquiries, whether by referral or by initiation of the prosecutor. Finally, on subject matter jurisdiction, multinational corporations are cooked. The prosecutor's list of environmental, natural resources, and land grab crimes by no means excludes their investigation of corporate complicity in more direct forms of ethnic cleansing and other crimes against humanity as well as war crimes. One hopes that the Holocaust was the last time we witnessed corporate complicity in genocide, but I'm afraid probably not, and Dean Kelly addresses that issue masterfully in his recent book. But there is extensive corporate engagement in modern warfare and assaults on civilian populations. Military contractors in particular, including the manufacturers of weapons, need to be particularly sensitive to this emerging field of liability. Of course, there remains the theoretical possibility of amending the Rome Statute to explicitly extend its personal jurisdiction to juridical persons. States parties could amend Articles 1 and 25(1) to explicitly include juridical persons. But other amendments of the Rome Statute doubtless would be required to cover the consequential meaning of including juridical persons, and they would be extensive in character. Careful consideration would have to be made to distinguish, if necessary, between natural and juridical persons for purposes of production of evidence, the exercise of due process rights, proper physical presence of the defendant who would appear for the corporation in relevant proceedings, state cooperation requirements unique to corporations, and discerning which penalties are available and enforceable against corporations in the event of a guilty judgment. You know, the idea of the monitor in our federal practice in the United States, it would be an interesting day for the ICC to inject a monitor into a multinational corporation to monitor and make sure that the operations of that corporation are in compliance with the Rome Statute. Then there would be the staffing at considerable cost of a whole new division of the Office of the Prosecutor with lawyers and individuals of business and financial expertise and who know how to investigate corporate conduct. Of course, such talent already is required as the prosecutor turns her attention to corporate conduct leading to atrocity crimes. The election of at least some judges would need to turn, at least in part, on their expertise in criminal law as it pertains to corporate conduct. Any group of amendments covering juridical persons in the Rome Statute would require approval by 2/3 of the state's parties pursuant to Article 121(3), and if that hurdle is leaped, then such amendments would have to be ratified or accepted by 7/8 of the state parties in order to come into force pursuant to Article 121(4). There might be a different path, namely negotiation of a protocol to the Rome Statute that would permit states parties that join it to opt in to cover juridical persons. However, such a protocol may be very difficult to negotiate, as it would still have to transform the Rome Statute radically to cover juridical persons only for those states parties ratifying or accepting the protocol. The protocol would have to largely mirror the complex amendments required for a comprehensive overhaul of the Rome Statute with straight amendments, and may still need to be initially adopted by 2/3 of the states parties pursuant to Article 121(3). My concluding paragraph. Any empirical study of corporate conduct internationally would not conclude that the presumption of corporate impunity is dead, as any reading of the news alone informs us that far too much corporate misconduct continues unchallenged. But surely the tide is turning towards challenging the presumption and the reality of corporate impunity, if not as a matter of criminal law, then as a matter of reporting requirements mandated by law or by international organizations or civil society, or as a matter of moral decision-making at the highest levels of corporate management. Professor Cabe and I co-chair the Working Group on Business and Human Rights of the UN Global Compact's Prime Initiative, where we seek to broaden the curriculum of business schools in particular to ensure that students understand the importance of compliance with human rights standards as they enter the corporate management ranks. We struggle against the view that this is a subject falling outside business and management instruction, and yet we have seen in recent years a healthy increase in curriculum offerings and activities that focus on the human rights agenda. That gives me cause for hope, As with the Supreme Court's affirmation of corporate civil liability under the Alien Tort Statute in Jesner v. Arab Bank within the next year, and the ICC's tactful and challenging journey into corporate criminal liability through the decisions and actions of corporate officials. Thank you very much. So I'm here for questions. If you could just lean back and get my water right behind you there. Yes, Professor. I think right over there.
Oh.
So I'm wondering if I can ask you a little bit more about the Jesner case, because I'm wondering what assumptions underlie some of the briefing, including your own. So there's a lot of attention on what the negotiations to the Rome Treaty really did or didn't demonstrate, and what's happened since then in terms of this 17, various treaties and so forth. Is that, do you think the court is going to say that's relevant, or do we actually have to step back to 1789 to what the scope of the understanding of international obligations and so forth is, and what's your own view on that? What's your guess about what the court will do? Because it seems to me that it looks real different if you travel back in time to 1789, and I found very persuasive your discussion about how about the other points going forward, starting with the Rome Statute.
Okay, thank you very much, Professor. I have no doubt that the Supreme Court will go back to some kind of original intent analysis, which will take them back to 1789. Now, we have seen this before in a lot of litigation on the Alien Tort Statute. We saw it in the briefing for Kiobel and some of the judgments reached. Yes, I think they'll go back to it, and I'm hoping that when they do, of course, they'll look at the issue of piracy and what piracy meant and how you executed the piracy on the high seas, which was through a form of corporate presence on the high seas through the ships. So I hope if they focus on that, they'll at least understand or accept the premise that the Alien Tort Statute, as the Supreme Court itself identified in Sosa v. Alvarez-McCain, is premised on the crime of piracy as well as the two other basic crimes that they identified in 1789. I would think that Justice Breyer may have some, I hope would have some influence here. His concurring opinion in Kiobel, I thought, opened the door widely to a more modern understanding of the Alien Tort Statute and its application in the United States. Of course, that was mostly on the issue of touch and concern and interests of the United States. But I just think it would be unusual, or it would be awkward for the Supreme Court to say that after 25 years, more take a few here or there, 25 years of federal litigation in the United States upon which corporate liability has been assumed under the Alien Tort Statute, that we will reverse that assumption after 25 years of litigation, none of which challenged that assumption with the exception of the Second Circuit. And perhaps the Fourth Circuit, I can't remember if the Fourth Circuit had something on this. I don't think so, but maybe they did. But so that, I mean, that would be my opening shot at that. I mean, I could go on, but I would just say that I think it would be awkward for the Supreme Court to look so antiquated on the issue of original intent as to say, well, the Alien Tort Statute, if we look back at Sosa, it will be only Sosa. But remember, in Sosa, we left the door ajar. And that door was not left ajar only for natural persons. We didn't say that. We didn't say that in SOSA, that the door is ajar for only natural persons. We never said that. So our understanding of the door ajar is if there's a corporate entity that is perpetrating these violations of the law of nations as we have defined them in terms of the character of their gravity, the SOSA test, then nothing precludes the application of that to corporations. So I would hope that they would just reaffirm and strengthen SOSA. I have no problem, with SOSA. Just in order to get on with life, I have no problem with SOSA saying there's a narrow band of subject matter jurisdiction. So fall within that narrow band and then get on with it. But don't bring in everything else, that you think is a violation of human rights. And I would just hope that they would see that SOSA, even with footnote 20, which I think was grossly misinterpreted by the Second Circuit, prevents corporations from being part of that open door policy.
Mr. Ambassador, thank you for your comments, some of which suggest you might be willing to offer some personal reflections quite apart from the specifics of any particular case or treaty or statute. Thanks to you and dozens of other people like you, it is my impression the U.S. has played what might fairly be described as a leadership role over decades in drawing attention to human rights issues, whether or not that's they attach corporate responsibility for those. Are you willing to make any comments about whether a perceived across-the-board withdrawal by the United States from playing a leadership role in various global initiatives is likely to impact the progress that you dedicated your life to making?
Well, yes, thank you for the opportunity to answer that question. It occupies much of my thinking all day long, quite frankly, since the election. Don't hold this against me if I do a little self-aggrandizement with this statement, but during the 1990s, we built something. We built the institutions of international criminal law. And the United States was right at the forefront of it, every single day. And, the story that isn't known enough is what does someone like me do, particularly as ambassador at large? I spend an enormous amount of my time on an airplane going to capitals, pressing governments to join us in building these courts. The irony, of course, that we didn't ultimately join as a ratified state the International Criminal Court would tend to leave the impression that, we must not have been doing anything, when in fact we were doing exactly the opposite. 2 weeks before I had to resign, with the administration of George W. Bush coming in, and we all had to resign then, I was still in Switzerland negotiating with the Swiss government about how to bring the United States into the International Criminal Court, and to do so with innovative thinking. And they were responsive to that. They were saying, okay, let's look at this. Do you think George W. Bush might run with this? I don't know, but let's try. And so there was a constant effort to do that. And I think along, of course, with a tremendous number of other governments that were totally at the front of it, and the Dutch government was right at the forefront. We really built something, and we led. And that is a unique quality of the United States. We lead with our values. We lead with our commitment to the rule of law. I mean, former Vice President Biden, you might have seen, had a really good op-ed in the New York Times, I think it was yesterday or the day before, talking about what it is to be leading with values and how important that is. My concern now, when we see this retreat in many different dimensions, I won't even go into the details, but you know them all these dimensions of retreat, diplomatically and in treaty law, that we've witnessed since January, that we are reaching a stage where the U.S. government will become irrelevant to these issues internationally. I mean, forget about leadership. Are you even relevant in the discussion anymore? My experience with the Rome Statute is, sort of a sad one. We pushed so hard for that, and I finally signed it on December 31st, 2000, with the full commitment of President Clinton and Madeleine Albright as Secretary of State, and signed that document in New York. And the point of that was to say, by gosh, we're going to continue to lead on this. We may not get it ratified by 66 senators in our lifetime. Judge Bergenthal mentioned 40 years for the Genocide Convention. I've always said, well, give us 50 years on the Rome Statute. But by God, we're going to stay in there and lead. And that's why we signed it. And now I'm deeply concerned that, and what I experienced since then, of course, is that the states parties of the ICC, and they're, it's all of our allies, for Pete's sake, they're just charging ahead. They're writing international criminal law through their judges who sit on the benches. There's no American judge at the ICC. We can't. We're not a state party. There's no American prosecutor. We can have some people in the subterranean part of the prosecutor's office, but the prosecutor will not be an American. And so we lose the opportunity to help shape that whole phenomenon of law building. We just lose it. It's gone. And therefore, when I talk with my friends in Europe or Latin America about the ICC, and they're all members of it, all of Europe, all of Latin America, there's no longer any real discussion about, oh, well, the United States, where are you guys on this? I mean, what would you like to contribute to our discussion? They don't care anymore. They don't care because we're gone. And if that's leadership, I mean, I'm in another universe of understanding of the dictionary. So I think it's very, very important. It's very important that we go back in and, the easiest, I always thought, after the election, I thought, the easiest op-ed, while we're all thinking so cooperatively, the easiest op-ed to write would be, all right, now one of the best ways to exercise our power in the world would be just, and it's so easy, with a Republican leadership, Republican president behind it, just go in and ratify the following treaties. I didn't even have the Rome Treaty on my list. I mean, I just had the Disabilities Convention on my list. I had the, CEDAW, the Convention on Elimination of Discrimination Against Women. I had some arms control treaties that are so very important. I had Protocol 2 of the Geneva Convention. For Pete's sake, everyone has supported that. The Law of the Sea Convention, the Pentagon wants the Law of the Sea Convention ratified, for Pete's sake. What is our problem? But we're gone. We don't have any judges on the Law of the Sea Tribunal in Hamburg. Zip. If you want an externship or an internship at that tribunal, by the way, it'll be hard. I've had students try. It's real hard. Why? We're not there. And you're an American walking in and saying you want a little internship with the judge? Are you kidding me? There are lots of others, lining up for that, who are states parties to the Laws of the Sea Convention, which most countries are. So it's just I'm sorry, I go on and on. Let's go on to the next question, okay?
Well, I think we all owe you a personal debt of gratitude for helping erect the system that we've got. So thank you for that. I can't resist the opportunity to pose a hypothetical to my former professor.
Okay, go ahead.
You hit me with enough of these when I was your student. And it goes back to the ICC. And one of the unique features of the ICC is this trust fund for victims.
Yeah.
I mean, if we were able to get prosecution of corporations off the ground and collect billions of dollars against companies, that would breathe new life into that system. But is there a danger that, if that were to happen, that if the prosecutor went after a Ugandan corporation, there would be a complementarity trigger in a much more robust way the Ugandan government would say, "Oh, well, no, you're really coming after our corporation to drain its assets for your
Yeah,
fund."
yeah.
Is that a trap? I mean, this is thinking way down the road, once we have jurisdiction and everything like that.
Yeah, I mean, it very much is it's the I don't know if it's a catch-22, but it's the paradox. It's the paradox of what we're talking about, which is the moment the trust fund loves to receive funds from corporate entities. It's a philanthropic objective that corporations can easily fulfill, and they're helping the victims of atrocity crimes. They can put that in their annual report. Everyone's smiling. That's great. The PR people love it. But of course, if the court starts to build a track record of going after corporations, then that kind of fundraising will dry up. It could easily dry up. So I perfectly agree with you. The whole fundraising effort for the Trust Fund for Victims at the ICC is a highly organized effort. It has superb leadership. I go to their events occasionally when I'm in The Hague, and it's something you all should look at if you're interested in the ICC. It's an aspect of the ICC where, in particular, I think Americans could easily step in and be a tremendous asset, both staff-wise and, frankly, with American funding, not through Congress. That wouldn't be permitted yet under the American Service Members Protection Act, I don't think. Although that'd be an interesting question to look at, technically. Certainly, corporate America could make a statement to that effect, or some wealthy Americans could make a statement to that effect. Oh, yeah.
This is a painful question that I'm going to have to ask. I'm going to ask it as a Jewish man, too.
Yeah.
Who's quite, powerfully affected by the conversation that we had earlier about the Holocaust. And this is in no way to derogate from the tremendous work that you have done, Ambassador, over the years. But during the same time frame that we had President Clinton in office, we had the genocide in the Congo. And we know that probably over 5.4 million people perished, although those numbers have been debated, and that conflict is ongoing, and that conflict is driven largely by corporate interests, and that most of our electronics have those rare earth minerals in them from that failed state.
Yeah.
And we also know that part of that conflict was driven by the preceding conflict, where over 800,000 people perished in Rwanda, and that it was very likely due to that war guilt that we helped to enable the Rwandan regime to go into the Congo. So how can we pat ourselves on the back with the former leadership that we had when something relatively similar to the Holocaust was going on during that same time frame?
Excellent question. Of course, you could say the same thing about Syria today. Talk about American leadership, and yet for 6 years on Syria, where has the United States been to end that horror? It really hasn't been there. And of course, nor has almost any other country been there to end that horror. In the 1990s, when you look back at it, I think you can find opportunities to clearly identify failures in the foreign policy making of the Clinton administration with respect to Central Africa. We did devote a lot of diplomatic attention to it in the aftermath of the Rwandan genocide. A former Michigan Congressman, Wolfowitz, became our special envoy to the Great Lakes region, was deeply involved in that. Susan Rice, as Assistant Secretary of State for Africa, was deeply involved in trying to get a grip on what was going on in the Congo. But I must say that one could easily conclude that not only we, but many other countries, Europe included, failed in properly responding to the horror in the Democratic Republic of the Congo. I mean, there's just no question that was a problem. We did move ultimately towards a UN peacekeeping presence there. That was sort of the default that we went to try to get a better grip on what was there. I went to the DRC several times myself as ambassador, and I went at considerable risk I even talked to, warlords I was driven secretly to their little hideouts to try to simply state to them, we are watching, we know that these crimes are being committed, and we will do everything we can to hold those who commit them accountable. Now, that's in the larger scale of the conflict, my little efforts were minuscule, and I think you can sort of fault, frankly, you can always fault us for not having a full court press to resolve the problem. But, it's an enormous, I don't think that diminishes from our leadership. What it means is that, yes, we failed in many dimensions of global attention to crises, and whatever leadership we did demonstrate in the Democratic Republic of the Congo was probably, in the final analysis, very deficient, very minimal. And we did not regard it as so central to American interests as to try to resolve it. I will say, I'm just trying to think back because your question triggers a lot of memories. We did a lot of diplomatic spade work on the DRC, but diplomatic spade work sometimes only goes so far. Sometimes diplomacy has to be backed by force. And we learned that, of course, in Bosnia, that ultimately by the time we got to mid-1995, force was backing up diplomacy, and it worked. Within weeks, it worked. Force worked by backing up our diplomacy in August and September of 1995. And yet the Democratic Republic of the Congo was a more distant and, I'm afraid, perceptibly more complex situation. I had a 5-minute sign. It's probably 1 minute now, but I think I can probably declare this at a close. Okay.